So, Auckland, Mr Chair.
Call Ron, Mark.
Thank you, and I really do appreciate the opportunity to take a second call on this small part, Mr Chairman, just so that I might finish off the point that I was trying to make earlier on. Mr Chairman, the point I had gotten to in my earlier call was around the questions that still hang in our heads as we deliberate on the bill before us right now that we would have put at a select committee and would have been able to have obtained answers to, summarised and incorporated into our report, which might then have become the reference material for this debate. But we don't have it. And the questions, and I'm really pleased with the last call that was just taken, because it touches very much into the area what I've just been deliberating on myself here in the House. So some of those questions that would have arisen at the Select Committee did the hearing start in September last year? How many exactly how many submissions were received? How many of those submissions, when did the chairperson start acting outside of the Act? What was the Auditor General's Office view of this? Did the Auditor General's Office, or the Audit Office, aware of it? I know, having been a mayor, that when the Audit Office comes into a council, they do not just go through the books and trace every dollar that the council has spent, or the appropriateness of that dollar spent. They trace the processes and the adherence to the statutory obligations and to the legislation of the Local Government Act. So clearly the Auckland Council has been operating outside of the Act, and that was known, hence the reason we're here today, retrospectively making legal their illegal actions. So the questions we would have asked is, what was the Audit Office view of this? Could we have a copy of their report? Could we have their views? Could we hear their views? What flexibility will be shown to other councils who fail to meet their statutory obligations in such a way, or is Auckland to be considered to be a different case and therefore treated differently as we are seeing here today? I mean, if Carterton was not to meet its obligations and to not take its submissions within the timeline, or have confused dates and be telling people, sorry, the closing date was the 14th of January, oops, sorry, we're wrong, it was actually the 28th of February, would that be acceptable? And there's a fundamental question that arises around the two closing dates, and that is this: how many people who thought the closure date was the 14th of January 2014 and not the 28th of February 2014 did not put in a submission when they could have, but didn't know they could have, because they had no knowledge that on the 14th of January, they had no knowledge on the 14th of January 2014 that Parliament would be sitting in urgency on the 19th of November 2015 to amend the legislation to make their late submission legal, and that they therefore should have put it in last January and had it legally accepted. And the next question is, what recourse is there for those people who followed the rule, did and realised that, hello, it's the 14th of January, can't put a submission in, didn't put it in? What recourse is there now in this part to allow them to appeal and to have their submission accepted now? Because I've just had a quick glance at the right of appeals under 155. It refers me further to sections 156 and 157 plus, and nowhere in there is there any opportunity for those people who acted in compliance with the law, realised on the 14th of January they couldn't put a submission in, didn't put it in. There's nowhere in there, in this legislation, is there an ability for them to get an appeal. And in fact, the appeals part of the legislation specifically rules them out, because you can't have an appeal on a submission that was never lodged. Catch-22, nasty situation brought about by fundamentally flawed legislation which has been amended retrospectively now. And I think that's unfair. And I think at the very least those people deserve the right to have a select committee analyse and scrutinise this, so they could have, even in a minority view, put a different view back to the House. Mr Chairman, I wait for the debate on the third reading. I think we've canvassed enough through part two to make it very clear that we think this is sloppy. We think it's shoddy. We think Auckland has been treated a little bit differently, and we would hope the same lenience would be shown in the Audit Office and by Parliament to any other territorial authority who's found to be operating its submissions processes outside of the law.
I call Shane Ritty.
I move that the question